Well, Senator Galey, it's great to see you. Thank you very much for taking the time to interview.
Yeah, thank you for reaching out and making the opportunity.
So, Parents' Bill of Rights, it's currently in Senate rules, but it's expected to be overridden by the Senate today. Now, this is a bill you've been working on a lot. What is the Parents' Bill of Rights?
Yes, we have been working on it a lot. Senate Bill 49, the Parents' Bill of Rights, first had its first committee hearing on February 1st. So here we are 6.5 months later, and hopefully today we'll be able to override the governor's veto. I don't have confirmation that it's on the calendar. But the purpose of the Parents' Bill of Rights is to, one, notify parents what their rights are vis-a-vis the public school system, and two, require the public school systems to implement policies that actually give voice or reality to those rights. So as it is now, if a parent wants information, they might not know who to contact. They might not know where to go in the public school system to get the information that they need. This would require parents to be notified of how to get information and have policies about making information available. The Parents' Bill of Rights does not dictate on a granular level how that has to happen. School systems decide that for themselves, but the school systems have to have policies that help parents to know how to get information and how to advocate for their child.
And why did Governor Cooper veto the bill?
He claims that it intimidates teachers or makes teachers afraid that they don't know what they can and can't teach, which the bill is very clear that there shall be no curriculum or instruction on gender identity, sex or sexual activity or sexuality in kindergarten through 3rd grade. So I don't know what is confusing about that or how a teacher would be afraid they're going to get in trouble. Probably if they have a concern, maybe I shouldn't teach that, they shouldn't teach it. That should be their tip-off.
Right, right. So this is more about transparency. We've seen a lot of these issues where kids will come home from school and have, a book or, some sort of curriculum in their hands, a worksheet that's got something on it that maybe isn't age appropriate. So do you think this is really a transparency thing, or do you think that Governor Cooper is right and that there are concerns about the parents or the teachers having an extra burden?
Well, it's definitely about transparency and that parents should know what's going on in their children's lives. Think about how many hours a day during the school year a child spends away from their parents in school and the influence that those teachers can have over those children. I think it's clear that during the pandemic, when the online learning was taking place, many parents across the country, including North Carolina, realized for the first time that their children were being taught things that were contrary to that family's values.
So some of the main pushback about this that I heard last time it was being debated is that if a kid changes their gender at school, for example, or wants to use different pronouns or a different name, there's been a lot of pushback from the left and from a lot of Democrats that this is something that should be confidential and should be kept to the parents, or not the parents, but to the teachers and the child in the confines of the school, and should not be shared with the parents. But this bill outlines that it needs to be shared with the parents. What would you say to that?
So we think about places in our law where there's confidentiality between two people and where that relationship exists. Those are things between a religious clergyman and their parishioner, because that person needs to confess their sin and that's part of their religious faith. There's attorney-client privilege, and the reason for that is that attorneys need to be able to do their best to defend their client, and if they don't know all the information, or if the client's afraid that if they tell the attorney something, then the attorney will turn around and use it against them, then that client doesn't get the best defense available. So there are specific legal reasons for privileges to exist. There is no teacher-student privilege. There is no teacher-student confidentiality, and we don't want there to be. Parents who send their children to public school systems should not be put in this position of feeling like they are giving up access to their child, the knowledge about their child's mental health and their well-being, that the school is going to withhold certain critical information about their child's health and well-being from the parent because the school is afraid of how the parent's going to react. That doesn't make any sense when they don't do that issues of pregnancy. They don't do that with issues of drug use. They don't do that with issues of bad grades. For as long as we've had public schools, as long as those problems have existed, schools have reached out to parents to get their feedback and their involvement and their assistance in helping the child. Why is it that it's different when it comes to a pronoun or official name change in the school's records? What's so dangerous about that to the child that's telling the parents about potential drug use or failing grades isn't also dangerous to the child? The reason I believe that there's that distinction is because the activists in the school system believe that the parents are going to tell the child something that they don't agree with. Not that they're going to do something hurtful to the child, but that they're going to say something that the school officials don't agree with. And that's such an intrusion on families' values and the proper role of the parent to parent their child with the morals and the values of the home that they've created.
Well, thank you, Senator Galey. We really appreciate you taking a few minutes out of your extremely busy day today to interview with us.
Great. Thank you for asking me. Appreciate it.